Any mention?
Yes, Mr. Ajay.
May I please, Your Lordships? Today I am not feeling well, so matter on item number 6 may be taken day after tomorrow, my lord.
Why day after tomorrow? We'll go to next week then. After a week.
Okay, my lord.
Who is the other side?
I put a private respondent, Lordship, because
not well. You have objection?
yes, Lordship, actually,
You have objection?
since they have been taking time, Lordship, that's why.
He says that he is not well.
If he's not feeling well, we can.
This is on the request of the petitioner. After a week. List after a week. We'll have it next week.
Most of the
Right, please, Your Lordship.
Yes.
Your Lordship, I beg to mention item number 12 from the hearing list. I humbly pray that this matter may be taken after 2 weeks, Your Lordship.
This is a criminal appeal.
Yes, Your Lordship. I am for the appellant in this case.
No objection, Lordship.
When?
After 2 weeks, Your Lordship.
12 on the request of the appellant. List after 2 weeks.
File, Your Lordship.
May I please, Your Lordship? Your Lordship, I beg to mention item number 7. I've taken consent from the petitioner, Your Lordship. I pray for 7. 3 weeks, Lordship.
What for? Why you want 3 weeks time?
Your Lordship, today the conducting counsel is having some personal difficulties, Your Lordship.
Who is conducting counsel?
M.M. Kurisi, Your Lordship. I'm for the respondent number 5 and 6 in this matter.
And for the petitioner, no objection, Lordship. No objection.
You have no objection. But even then court has objection.
Your Lordship, item number 7, 8 and 11 are connected matters, Your Lordship.
11 are
for the petitioner, madam.
Connected matters.
Madam.
But they're not represented by the same counsel.
Yes, madam.
So what happens then? We'll have to segregate it here the other matters.
Mr. Qureshi is for the respondent in item number 11.
11, Your Lordship.
For the managing committee, madam.
Item number, he's mentioned item number 7, isn't it?
Madam.
Then item
Lordship.
7
And 11, Your Lordship.
are connected.
Madam.
And how many matters are connected?
7, 8 and 11, Your Lordship.
7, 8 and 11.
Mr. Qureshi is for the private respondent in 7 and 11.
11 you were petitioner.
I am for the petitioner.
But then are they tagged together? They're not tagged together, isn't it?
They are
If it is not tagged together, then what is the difficulty? It is listed separately.
They are tagged together. They are tagged together, madam. These are
But then it appears that since it is listed separately, it appears that they are not along with 372. The petition 372. It seems 37 and 8 they are tagged together. 11 is separate.
madam.
So that will the adjournment of 7 and 8 will not affect 11, isn't it?
My lord, all these matters are coming together, my lord, for last few weeks, my lord.
No, but then that has to be on the basis of separate prayer then.
Your Lordship, I'm praying for item number 11, Your Lordship. So,
You are paying for item number 11.
7 and 11, Your Lordship.
7 and 11.
Your Lordship.
But then 7 and 11 is not tagged together. These are different. And in 11 you are?
I'm for the respondent number 5 in 11.
You have any objection?
No objection, my lord.
7, that's one number 5 and in 7?
Respondent number 5 and 6 in 7.
Okay, and 11?
11, respondent number 5.
Number 5. So nobody has any objection. So if 7 goes, then 8 also goes. It is tagged together.
My lord.
And 8, who is appearing for the petitioner?
And for the petitioner, Lordship.
And 8, you are not a party.
No, Your Lordship.
So there is no prayer for adjourning the 8.
I don't know, sir.
7 and 11, just say. And the request made on behalf of the private number so and so. List this matter after?
3 weeks, Lordship. 3 weeks, Lordship.
Why 3 weeks? These are all matters. 2 weeks, not 3 weeks. 2 weeks. And what is to be done with 7? 7 just on the request of the parties, list after 2 weeks. Yes.
Highly obliged.
May I please, Your Lordship, I beg to mention item number 5. The reconstruction of the file is not yet completed, my lord.
Well, when do you want it? How long will it take?
After 2 weeks?
The learning council where the petitioner submits that the petitioner is yet to reconstruct, yet to fully reconstruct the file which was gutted by fire. And prays for grant of some type. Mr. Hajarika appearing for the, you are also there. Councils appearing for the respondents. I have no objection. Prayer alert list after 2 weeks. Yes.
I'd like to mention item 4, my lord, of the hearing list. And this, madam, my lord, this was heard earlier by your lordship. I'm waiting for some instructions in this matter, my lord.
You have given the copy.
Yeah, regarding
What case is, what is the?
this is that matter, my lord, where the government is seeking resumption of land.
Okay.
Or the affidavit filed by the private
Yes,
respondent,
Mr.
my lord.
Lindo said
Yes,
they
they
have
filed
never
some
taken
affidavit, my lord, whereby they have brought in the data which he had obtained from archives of Assam. My lord, concerning that, I need certain instruction from my client, my lord.
It is 2015 matter. What instruction?
I'm
you
just
need
praying for a
after
week's
most of
time, my
10
lord.
years?
I'm only praying for a week's time, my lord.
These cases that you have never taken, even never.
Absolutely, my lord.
That is what. So if
Something
that
has
is the
come up
thing-
in something
that
has
is the
come up
thing-
in that affidavit, my lord,
See,
which
unnecessary way to pursue a case. If there is no right, we cannot.
now,
see,
in fact, my lord, I just want to make myself sure because there's something has come up in that affidavit which he had filed. I just want to, my lord, clarify.
when this affidavit was filed by him?
This affidavit was filed by, I think, last year, my lord.
Then you should have taken instruction then and there.
I was going through yesterday, my lord.
You took 1 year to go through the same.
No, my lord. I did go through last time also. On careful perusal last night, my lord, I found out something, my lord. And regarding that, I need certain instruction just for a week's time, my lord, a week's accommodation.
Please make sure this kind of matters is unnecessary, should not be kept. If you have at all not taken over possession, you have no right. It's unnecessary. Just give me 1 week time. You seem very indifferent by it. Huh? Just for the request of
Obliged.
the petitioner, list this matter after a week.
Obliged.
All right.
May it please, Your Lordship.
Yes.
Lordship, item
Any
number
more
15.
matter left in the list?
I'm praying accommodation for a week time, my lord.
Which one?
A week. Item number 15, my lord.
New matter.
A new matter, my lord.
You were there.
Yes, Your Lordship.
You have objection.
No objection, Your Lordship. Miss N.G. Shalla also is not available today, Your Lordship.
Yes. When you want it?
We can have it next week, my lord.
Next week we will not have. Make after 2 weeks on the request of the petition. Make sure take bit longer time, but then do it.
Lordship.
It's no use, you see, asking time repeatedly, 1
Lordship,
week, 2 days, 3 days. Yes.
Obliged.
Obliged, Lordship.
Lordship, I beg to mention item number 2 and 3 for little bit accommodation, Your Lordship. I supposed to prepare the compilation. There's personal difficulties here.
Item number 3.
2 and 3.
This is parted matter.
I supposed to submit this compilation, Your Lordship. Due to my personal difficulties, I was not in position to prepare. So if you kindly accommodate, Your Lordship.
2 already urgent. 2 is. Who mentioned item number 2? No. Escrow is different item. Item number 12, not 2. Yes. Item number 12, appellate. Where is from 12? Come.
But subject to lordship convenient, if the senior is having the paper may be given to both the parties.
See, so far as this court remembers that it was heard on a particular day,
Yes, yes,
and
yes.
it was passed,
Heard
for,
at
or
length.
passed over for the day. The
Yes,
next day
yes.
it was supposed to be
Yes,
taken.
yes.
And thereafter time was granted.
Right.
Now the thing is that if there is a lapse in between, you see
Exactly,
this court
exactly,
forgets.
exactly.
Now that is what the problem is.
Right. If
So
lordship,
there is no use of keeping it part heard there.
exactly.
We'll
It's a
release
very,
it.
very bulky case. So if lordship find it convenient, matter may be taken up tomorrow, day after tomorrow also, since he has all the papers.
Tomorrow I was
Or
having
next
little
week.
Friday is always uncertain, you see, Mr. Sanglesh.
The next week, my lord, since he has all the papers now, supply the copy to my lord and all of
If it
us.
takes too long, then we'll release it from part heard.
My lord,
There
that
is
would
no
be
use keeping
really,
it part heard.
that is why, my lord.
That was the school matter, isn't
School
it?
matter, permanent SSA.
That you were removed by another person who
Yes.
you were removed on the pretext that you do not have the requisite qualification,
Yes,
and the
yes.
person who was inducted, you also did not do
He doesn't.
That is what the case
That
is.
is the issue.
When?
So next week, Your Lordship.
Okay, just see if you cannot do next week, then we will release it. On the request. Okay, Mr. R. Devnath, Learned Counsel, appearing for the. You are appearing for?
5, 6, and 7.
Question number 7. Please for grant of some more time, enabling him to file a compilation of
According to relevant papers, he said.
documents as required by the previous order of this court. Mr. Sir, Senior Counsel appearing for the petitioner has no objection. If you are allowed, list after a week. Please make sure you do it, otherwise
Yes,
it will be useless.
Yes.
Yes.
Okay.
Supplementary cause list. Item number 1.
Yes, Mr.
Item number 9.
Yes.
This is regarding the Akung, my lord, Akung Nukma. The last hearing there was some part of hearing was done, but however during the course of hearing, lordship.
This problem is that you see this court has heard so many matters, and nothing
Yes,
could be finished.
Yes.
And then now this court is confused.
No,
What is the
actually on the verbal instruction, because as per the they were asked called for the record that whether I have make a submission on the last earlier occasion whether there was any deposition, because my main challenge was what in the GHTC.
Is this a case that where is that non-framing of issues? Was it? Is it the case here?
No, no. This is their arcing. There's a part of our arcing. That's the case. In fact, earlier this is the third time they have come. Earlier, the High Court set aside the previous orders. Then again, they are proceeding against that order. Also, they have again come. That time, senior counsel Mr. Kenji has consented. The records of the district council will be taken care of. On that basis, it was sent back.
It is not on that Dore Sangma basis.
No.
This is not a.
That will not come. The submissions made, everything is there.
So this court is basically confused because see, this is what the problem is.
Yes.
2-3 matters are hard and nothing has been
I know.
decided, and then
I know. I'll try to assist you.
that's all right.
Yes, the basically the contention of the petitioner here, lordship, is that Akung, what the petitioner claiming that since from British, the petitioner, the particular Akung, the Adugachor has been in existence, your lordship. But suddenly, my lord, which I have annexed it, lordship, there was a order passed by the EM where cancelling the
Annexure 8.
Yes, lordship. Annexure 8.
The Dore Sangma was not referred here in this matter.
No.
And there appears to be a copy of
The
judgment here.
Dorasama's case earlier, when it came in the first time, both the orders were set aside. EM inches and CM order were set
No,
aside.
but then there is a copy of these things.
Yes,
There's
yes,
one
I
copy.
have
Yes,
raised
that
this
is what.
one. They're saying that I have stated that I mentioned in the
Is it
mega
your case that no issue was?
yes,
no
yes,
issue was.
yes,
That is
no
what.
issue of
No issue was framed.
no
The
issue was
matter
framed, no
yes, decided.
evidence was laid,
And there was an order, I think, pointed out by Mr. Day,
Yes.
that wherein it was recorded the issues were fine.
yes, that
Now,
Order sheet is there.
yes. Now, basing on that, you wanted to see instruction, and that is precisely the reason why it was adjourned.
yes, because I said
Now, tell us, can you show us any order which says, or by which it can be projected that no issue was?
yes, but from the entire record, because only order it was reflected.
What was
that-
the order, Mr. Day? What was the order that case that day you referred to establish that?
'26, 2016 is all. 16. 26, 8, 2016.
Here in 24 to 2015, both the parties are represented, heard the issue suggested by both the parties, fixed for orders. So
Yes, page 151. Page 151 come to order dated 28/12/2017. It says accordingly, whereby this court has framed issues, examined the witnesses of both parties.
Yes.
So
an order sheet is there.
now
That's why
you wanted
yes,
basically to clarify this aspect of the matter by saying
yes,
that though it has been reflected that the issues were framed,
yes,
but then
in reality, it
In
is not
fact,
there.
no, yes. So then how do you say that? Why should you presume something which is not
No,
reflected in the order?
because
Otherwise, we will believe this order.
no, that's why I am saying, because if there is any where the evidence is recorded, the statement of the particular person who give the evidence, their statement has to be recorded.
No, my lord, two things. Before my learned friend start and press this matter, my lord, two things which my lord has to consider first, my lord, before he give a submission, lengthy submission, my lord. Here, the case of the petitioner that he projected last time is that the issues has not been framed. We have produced the documents, my lord, which suggest that the issue has been framed. This is the order sheet. Order sheet is there.
Order sheet is already there. It is appended with the
Order is even here also it is mentioning.
No. Order sheet is there that on particular date, issues was suggested by both the parties was heard, and issues was framed. Now, subsequently, he's bringing out another point, my lord, where evidence has not been recorded. Now,
see, Mister, this order at page 2812 specifically says the court has framed issues, examine the witnesses of both.
Correct.
Now, see, this is a judicial order.
Yes.
So, until and unless there is something to contradict this recording of this fact, this court will not disbelieve this order.
My lord.
The law is that we should believe it.
What I'm pointing out is this, my lord, or my submission is this. Mr. Sama has to point out that this order
exactly. That is what
doesn't exist, my lord.
See, precisely that is the reason why he took time in the last time.
Yes.
Now this court remembers it.
Yes.
He said that the
issues was not framed.
The fact recorded in this order is not correct. So he said that he will go to the entire order sheet and place it before the court there to show that no issues were framed. Now that is where you have to show us. That is why you refer to this Dore-Sami case.
Yes,
Dore-Sangma case.
Yes, but lordship. That's why I'm saying, if there is any evidence laid by the recorded in the EM court, there will be. It is as I said, lordship, where lordship has availed, that any evidence laid or recorded,
that will be available.
It will be available in the.
Now your case.
I'm saying that
it is
not there.
Now where is your statement to that effect in the writ petition?
Yes, I have make a lot of statement, lordship.
No, about that only.
I said that para 17 or 18 also.
You just said take us to that specific statement where you have said that do not take the court somewhere else. Just confine yourself to that. That where you have made those statements that no issues were framed and no witness was examined. Otherwise, you will not disbelieve this. Mr. Day, are you holding the record with you?
Yes, well, the order sheet is with me.
Order sheet. No, but then what about the other aspect, the entire record?
No, my lord, I have last time, as my friend has suggested, there is no issue, so I have asked for the order sheet.
It's all right.
Order sheet will speak, my lord.
And now he says there is no evidence also.
Now, that is what, my lord, first he has to point out, my lord, what I humbly submit before this honorable court.
Let us first see what contention he has raised in the writ petition.
No, first, my lord, he has to settle down these issues, my lord. Then it will be very clear whether evidence was required or it is not there. That has to be examined by this honorable court.
So recording of evidence is not compulsory, you want to say?
It is not compulsory, my lord. It's all about you bringing the.
Shall we take it as that you are conceding to what he says? That
No, not exactly, my lord, because the witnesses, my lord, they are there in the court when a NOCMA is registered from both the sides, and statements are recorded, my lord. Then there will be claim and counterclaim. If the claim is very strong, my lord, and the majority of the Mahari is one particular person to be the NOCMA, my lord. Now, my lord, he cannot say that he will have a different clan. It is the same clan.
That is all right. That is all right. Why you are going to facts? This court will not go into all those things. We are exercising power of judicial review. So we'll just confine ourselves to the procedure adopted by the authority while passing this impunity.
Yes.
Nothing more than that. We are not going and examining the merits and demerits of the law.
Exactly. But here is, my lord, what my learned friend has to point out, that issues was not framed.
That is what. See, this is all right. This is, you have said it. We are on that aspect only.
So
you just show us anything.
Yes,
which are-
para 18 I have mentioned. I have mentioned, but not speak, but I have stated that without following due process of law, the due process of law is include of all this one.
Where is that specific statement that you say no evidence was recorded or no issue was framed? That is a statement of fact. It is not a question of law that a lawyer statement will be. You have to say it.
Your Lordship, in this, but in our appeal petition before the learned court below, we have stated, but that I have not enclosed it here, Lordship. That is the part of our pleading. And moreover, this
So
there is a different one order. There is
whatever
one
is material, you have not enclosed with your petition.
But the fact of the matter is, though due to some bona fide mistake, I'm not specifically mentioning of that. But it is the fact that there was no evidence, no framing of issues, no issue was discussed.
See, you cannot
there
say
is no
it
conclusion.
until and unless you make this statement. Where is that? Yeah, why should we go by your verbal statement? If you say this is a ground for challenging the impugn order, then it has to be specifically pleaded there, so that they can reply it. You just cannot at the hearing come and raise some point which basically catches the other side by surprise. You cannot do it.
Yes, but
this is a statement of fact. They must get a good opportunity to reply to it.
But but yes, Lordship. But one thing is very clear. Even they are also is not able to produce those deposition and the statement that we have made before.
First, you have to
the
see,
court.
say it in your writ petition so that they get a chance to counter it, rebut it. If you do not say it, how they will rebut it?
Your Lordship, I will on the next I will produce the statement. It is you have make a plead in the learned court below, which I the petition which I have not enclosed here, Your Lordship, because it is there, Lordship.
No, where they have made a specific, is there in the writ petition? Copy of the writ petition is here.
Writ petition in the but in the while we filed an appeal against the order of the EM, the CEM that we have make that amendment, Lordship. It is there, but despite of all
Mr. Day says the recording of evidence is not compulsory. It is only when the authority concerned feels is necessary, they may.
Otherwise, also,
So,
Your Lordship.
Just where is the provision which says that evidence should be recorded?
Otherwise, also, Your Lordship, there is a direction from this honorable court also. There are two things which I make to submit, Your Lordship. That neither they have followed the basic principle, the
What is the
procedure
basic principle?
of rule that which I have submitted.
See, basic principle
Nor
is a-
they have gone they have passed the order.
Wait, you say basic principle. What is basic principle?
Principle, I ask.
Two general statement. What is basic principle?
Yes, the one is they have never recorded a statement of the. There is
Where
no
is that? You have not
statement.
pleaded it specifically.
That's
You have
why
not
I'm saying.
pleaded
That's
this
why I'm saying.
specifically.
Another one is the High Court order. Or High Court also has. I have passed an order to go by the record and pass an order, but they have not gone
But
even
then
by
this
the
order,
record also.
dated 28/12 makes your judgment incorrect. So we will record it. We will pass the order. Necessary.
Your Lordship,
These are the two grounds.
No,
that is enough.
I will satisfy on the.
No. Then which way is there?
Even this order, Lordship, there's a different writing of the order
Have you
because
seen-
I have to
have you
say the
seen-
order.
Have you seen that page 151? That order dated 28/12/2017. Have you seen it?
Lordship is
in your writ
28.
petition.
Even this order, Your Lordship, there are.
You appear to be very surprised when court points out to something. It is your petition. You must know. You are saying something which is contradictory to this order. See, whatever has been recorded in this order. You see, if this order was not there, probably court would have believed you. But then there is a specific recording. Why should we disbelieve this order?
No, Lordship, this there are same type copy order of the page 151, 28, 12, 2017. This same order which I have enclosed also there is
No, this order, this 151, you have this page you have enclosed, isn't it?
Yes, Lordship.
Now this is order
and
by the district council, isn't it? See, read the first paragraph. What 28/12 says?
Heard both sides
yes
in detail referring the direction issued by the Honorable High Court on 27 July 2013, WPC so and so, whereby the executive member, Land and Revenue JCDC Tura, directing to decide the respective claim of the party appraised after giving full opportunity for putting up their respective case. Accordingly, whereby this court has framed, issue, examined witnesses of both parties and heard the parties as directed by my predecessor.
Yes, that is enough. That much is enough. That answers your submission. That part answers your submission. This is specifically recorded. The court has framed issues, examined the witnesses. So both of your contention goes.
That's why I'm saying.
Now you say that 2012 order is not correct.
Yes.
Where is that plea in your writ petition? Have you said it? Has you said that this facts recorded therein is not correct?
Yes, I have mentioned.
Where you have said just show us to come to the writ petition? You just say that this fact, you have to say that this facts recorded is not basically based on materials on record. So any finding recorded by a court without any materials on record will be good ground for interference under judicial scope of judicial review. This will be perverse finding. Mr. Sangma, you have not prepared. It seems like your last occasion also you have taken time to reply all those things. You know this issue will come up again and again. If this court forgets, also other side is there to remind it. So you know you should have come prepared to answer these. It seems you have not done enough homework.
Last chance, my lord.
No. See,
No, actually,
the problem is, see, the court suffers more than more than any of you. See, this court forgets thing and then it takes time to recollect. You see, again have to first get the facts and then come to the thing. That becomes a problem. Otherwise, these issues are confined to this. We do not have to pass any lengthy order also. A small order will decide this. This is your plea. We find the answer is available already on the materials on record. That is okay. We can answer it. There is no problem in it.
But
we do not have to write even in details also submission recorded by the party.
Only the problem here, Lordship, I as mentioned due to, of course, I have not specifically mentioned in the petition regarding the recording of the statement and all. But in the fact and reality, it is not there because they have just mentioned.
Okay, we understand. But then if you say it is a fact and regularity, this is a statement of facts, isn't it?
Yeah,
so once it is statement of facts, the other side must get a chance to revert it, isn't it? So if you do not give them an opportunity, how can it be possible? If suddenly at the hearing you say something which is not raised in your writ petition, if that is the ground, that should be a valid ground for interfering. You should make that specific plea in your writ petition. Nothing. There is not even a statement that no issue was framed, no witness was examined. Nothing is there in your thing.
Yes, but in the entire record only the consensus in your lordship that they are not able to even in the court of EMCM they have completely fair in the various order the crack of the case they have just
is it it's an admitted fact that no witness was examined, no issues were framed.
They were examined. The order itself speaks.
That is the problem.
That's why they said only order it is reflected. I have admitted there is some mistake in my pleading that I have not mentioned, but
see, that is mistake that is fatal for you. And this case is pending for quite some time. You should have corrected it if that is your main ground of argument. You should have amended your petition also. You could have done that also. This is 2018 matter.
No, earlier because because of changing of lawyers. Because
when did you take it over?
No, I'm the petitioner, but other side they have other side they have changed.
Change of the lawyers, other side.
Mr. Senior advocate recently he was there when then we.
Okay. Mr. Pretty Sangma, allow us to pass the order.
No, Your Lordship, only last chance we you may be reflected in the order, because I will satisfy the court. If the next time not able to satisfy the query of the court, you can pass necessary order. That what my statement may be recorded in that. The next time you can see the order, so that court will not forget or could confuse, because yes, because no, I'm saying what I'm humbly submitting, because due to some there is some mistake.
What you want this court should record?
Yes, that on the last chance after that, that my statement may be recorded, so that court can pass a necessary order giving
last
opportunity.
chance
Actually, Lordship, on the last occasion that is actually
chance.
supposed to be not on the record is there actually.
Last chance to you for preparation.
Not because even Lordship, that record even they are supposed to produce. Where is the
See,
deposition?
why should you? This is your case. Burden is on you.
This order sheet, my lord, this order sheet will not speak wrong, my lord.
What is that order sheet?
My lord, may kindly see.
Your problem is that you are raising a plea which is apparently wrong in view of the order, which is appended with your writ petition. That is your writ petition. You have brought in this document to contradict your submission. We do not have to wait for their reaction. We will just reject your submission on the basis of this order.
Even he want to
That is
restore back the
enough.
order which was set aside by this Honorable High Court. Which was set aside by the Honorable High Court, that also he want to restore back.
Now, my lord, the first glimpse of his argument, my friend's argument, is this: my lord, the order suggested issues
We are
was
not
not
ready.
clear, and he was not given an opportunity. I have shown the documents by which he has suggested certain issues. Now, my lord, this is the order of the.
That is a part of record here.
There is a part. This is not part of record, my lord.
No, but then that wherein he has suggested some issues.
Yes, my lord.
What is that? What is the page number? Mr. Sangma, we are not inclined to grant time. We will finish this matter. Unnecessary. This will be a futile exercise. You see, like giving you.
Only thing is that he can do, my lord, I can suggest that he can withdraw and he can amend his draft, my lord. That is the only thing he can do. But with this draft, my lord, it will be very difficult for this honourable court also to pass order.
That is up to him. That is up to him.
Lordship, I pray
Now,
that,
now, my lord may kindly come before I show my lord the orders. My lord may kindly come to page 27, the prayer portion of
But
the.
then why don't you just confine yourself to that? What you
these
say?
are the two submissions that I would like to give before this honourable court, my lord.
But then he has not finished that way. So
No,
that event.
because this court cannot intervene, my lord, in this petition, my lord.
27, page
27 is the prayer portion. My lord.
Yes.
Now, my lord may kindly see from the
Huge prayer. This is a very long prayer.
from the ninth line, my lord.
Line from bottom or
From the top, my lord. 9. Should not be issued to set aside and quash the impugn order dated so and so.
Yes.
So and so in GEGDC revenue this passed by the executive member in charge land and revenue. The judgment and order dated 14/6/2016 in GEGDC revenue number so and so of 2015 passed by the CEM GEGDC and void impugn order dated so and so 28/12/2017 passed in GEGDC number so and so, my lord, passed by the executive member in charge land and revenue, and the judgment order dated 12/10/2018 passed by the GEGDC, passed by the chief executive member, and will be pleased to uphold the final judgment and order dated 15/3/2013, my lord. Now, my lord may kindly see this order of 2013 has been set aside by this honourable court, my lord, and remanded it back to hear the matter.
Where is that order by which it is set aside? What kind of things you are?
My lord may kindly come to page Annexure 14. 130, my lord, page. This is the order of Honorable Justice T.N.K. Singh, my lord. Page 130.
130.
130, my lord. The relevant page is on page 131, my lord.
Yes.
Paragraph 5, my lord.
Yes.
On perusal of the record, as well as after hearing the submission of the learned counsel for the parties, it appears that the order dated so and so was passed by the executive member in charge, Land and Revenue, Garhwal Saranamur District Council, without giving an opportunity to the opposite party. In the same manner, the order dated so and so, 15/3/2013, was passed by the chief executive member, JHDC, without giving an opportunity to the opposite party. As such, only on the technical ground, the violation of the principle of nature is both the order dated so and so are required to be interfered. And accordingly, both the orders dated so and so are hereby set aside.
In that matter,
Yes, ma'am.
the plea was only that no opportunity was given.
Yes.
They did not specifically say no issue was framed. Nothing.
No, nothing, my lord. Now they come
So
with a new.
this comes as a new plea here. After
New
remand.
plea. Yes, and the plea is not there. My
Yes,
friend
there
has not
is no-
taken the
but
plea.
then at the hearing is raising.
No, at the hearing, can it be, my lord? Because we
Okay, so now this order dated 27/5/2013 is sought to be Acha, I think the 15/3. 15/3 seeks to be upheld
yes.
by this court.
No, it's set aside, my lord. 15/3/2023.
No, but then this prayer.
The prayer is to upheld, my lord. How can my lord upheld this order, my lord? My lord is not sitting in review, my
So
lord.
your prayer is not maintainable.
It's not maintainable, my lord. So the best thing, my lord, my friend can withdraw it and file a fresh, my lord. If he is aggrieved, he can.
That is for him to decide. If he doesn't do it,
Lordship, 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 I will amend this one, or I will just on the next day I will withdraw it, Lordship. but now I just get an instruction. Will go through on the next day. If it's necessary, I will withdraw.
See, whatever has been pointed out is a part of record.
Yes.
Okay. So, in absence of any specific pleading in your writ petition, you cannot refute it. You are not in a position to do it, and if you raise it also, it is liable to be rejected. Now, all your submissions stand countered by the very document which you have annexed in your writ petition. So, what remains for you?
Lordship, that's why I pray only one more time on the next date. If it's not true, I will withdraw with a liberty to file, but just go through and get the instruction also from the prisoner, and that my submission also may be recorded, so that
How many opportunities you take?
Only last time was I got put a record, and this is second time. I'm not avoiding. I was trying to assist the court, but only because some queries cannot simply I just answer. I have gone through actually, but that pleading. I realized that pleading was not there, of course. But I have actually the issue which I have raised is very pertinent issue actually. But there is some defect I admitted in the petition. Yes, it is technicality, of course. What they are objecting, I admit there is a mistake in my petition.
So that mistake, whether now.
But only Lordship, only because of due to some technical mistake.
It is not a technical mistake.
No,
he has not narrated the facts correctly, my lord.
That's
And he has come with a wrong presumption, my lord, that issues was not framed.
No,
but
but
the order sheet speak otherwise, my lord.
The prayer made be here is not maintainable. See.
Yes, that's why I'm saying that I will amend.
Order passed by a coordinate bench should be interfered by this court.
Yes, that's what I will. I will
15
amend.
has been set aside by order of High Court, and you want that.
I will just get the instruction from the petitioner. Either I will amend and file a fresh petition.
Learned counsel for the petitioner, and also just record so and so. The main contention raised by the petitioner in this case is with regard to the we do not say the petitioner challenges. The petitioner challenge to the impugn orders is mainly on the count of non-framing of issues and non-examination of witness by the concerned authority before passing the impugn order. the submissions, the contentions of the petitioner stood countered by the respondents, you just say, on the basis of the documents appended with the writ petition itself. The respondents have pointed out to the order dated 28/12/2000, 28/12
2017, 28/12/2017, page 151.
to negate the contention raised on behalf of the petitioner. No, to project, just to, before you say to negate, to project that there is a specific, that it has been specifically recorded that the issues were framed and witnesses were examined. Before this matter was, before the matter was heard and impugned order was passed. Stop. It has also been pointed out to the prayer. It has also been pointed out by the respondents that the petitioner has made a prayer to uphold the final judgment and order dated 15/3/2013, passed in GHDC Revenue Appeal number 13 within bracket S/C of 2010. Whereas the said order has already been set aside by this court. By order dated, what is that order of TNK Singh, Justice TNK Singh?
12/10/2018.
Where is that page?
There's 159.
Hmm? 15, my lord.
The order of the
High Court of the order of the High Court. TNK Singh's order, Justice TNK Singh's order. Just now it was pointed out.
Yes, 27/5, 27/5/2013.
Yes. It is there at page 130.
130.
What you said is been set aside by this court. In this court by order dated, 27/5/2013, passed in WPC number SH 79/2013. Paragraph. Faced with the situation of the learned counsel for the petitioner, paid for grant of some time. To what? For what?
Lordship, I will just get the instruction. I will withdraw with liberty to file fresh, or I will amend that this one. That's just
okay. We'll just this is paid for some time to take necessary instructions. In the matter.
That part may be recorded, my lord, if I can just inject, my lord, that to withdraw. He is
No problem.
taking-
I have no
That
problem.
is something.
Again, he will come with the third
No,
prayer,
no,
my
no,
lord.
no, no.
If it is not done, then he may have some. His clients may have something will become answerable. Do not make him. You are.
No, but he's submitting, my lord,
Your
and
fight
it's
is-
life, my lord. Now,
It's all right, but then it may have a negative impact on his.
my lord, he's very strong, my lord. Negative effect doesn't affect him.
Oh, just what is it? Strict necessary instructions. Instructions in the matter. Just say. Though this court. You see, although this court at this stage is not very much inclined to grant more time to the petitioner. However, however, for the ends of justice, the petitioner is afforded with one more chance to take appropriate instruction.
Lordship.
The counsel for the petitioner is given one more chance to revise this. Without saying the petitioner has been given, just a counsel for the petitioner. When? Next week?
Next week, my lord. Or Friday also, you can do, my lord. Today's Wednesday only. One day only, he need to take instruction.
Not this Friday. The next, not next day. Not this
Let
Friday.
it be on Tuesday, my lord. This coming Tuesday, my
We
lord.
will not say this.
Tuesday, my lord.
According to this list is a matter after a week. See, Mr. Sangma, please see
Lordship,
those parts.
I understand because there is a defect in my.
Your own submission is countered by your own documents. What else?
Of course.
Item number 10.
There will be a bit correction here, there in the things, orders and all. Yes. Yes.
This matter had earlier gone before Honorable CJ, my lord. Now it has come back here.
Now what is there for the
Petitioner
petitioner?
counsel is notified.
None appears for the petitioner. Mr. K.P. Bhattacharjee, Learned GA, is present on behalf of the state respondents. This is met after 2 weeks. Yes, next.
Item number 13.
Lordship.
Yes.
On the last date, Lordship, this Honorable Court had raised a query as to the definition between a lacuna and error, and it was part heard, Lordship.
This is regarding that, my lord, recalling of witnesses, my lord. The application under 311 was allowed by the trial court. Recalling the PW1 for re-examination, my lord. That order is under challenge, my lord, in this matter.
I think you have to refresh the mind of the court, you say, like.
My lord.
This will be difficult.
My lord, the order is at page 44, the order under challenge, my lord.
Yes.
May I read, my lord?
Yes.
CR put up accused so-and-so is present with defense counsel so-and-so. So-and-so is present and submitted that the petition under section 311 CRPC white petition number so-and-so for recalling the PW1 complainant filed by him on the last date as because some development has come to light from the evidence of other witnesses which requires to be tested from the complainant and that he has omitted to ask some facts from her as per her statement in CD. Learned defense objected the recalling of the complainant as she has already been examined in both in chief and in cross. She further objected on ground that no development of any fact from other witnesses. Defense objected recalling of the complainant as it will amount to harassment to the accused and she submitted that the learned PP should have invoked 154 Evidence Act of at that relevant time. As per provision under section 311 CRPC is provided also for recalling and re-examining of any person already examined if his evidence appears to it to be essential to the just decision of the case. It is settled law that the discretion and is vested in the court under this provision where is to be exercised judicially and not arbitrary and that the witness may be recalled or re-examined at any stage or proceeding where is essential. My lord, the relevant part is the last paragraph, my lord. On going through the recorded evidence and the statement of the complainant under section 161 CRPC and also confessional statement of the accused, which landed PP submitted, will also be filing application for calling the recording magistrate is seen some essential facts requiring to be extracted from the complainant in order to enable the court to reach at the just decision of this case in respect to the cause of the death of the baby child. Hence, the prayer of the prosecution is allowed. So and so, my lord.
Yes.
My lord,
What is wrong in this order?
My lord, there is no reason assigned in the order, my lord, as well as in the application filed by the prosecution.
The court says there certain essential facts are required to be extracted.
My lord, the order is very cryptic, my lord. There is no, my lord, the application also has to be there.
But then you know the intention. What more elaboration you say? You know the purpose of recalling.
My lord, I do not know, my lord. There is nothing mentioned in the application. My lord, may kindly see the application, my lord. My lord.
Court said that there appears to be certain facts,
my lord,
which requires to be extracted. So that is the reason given.
My lord, there is.
Now, if you go by the proposition of law,
my lord,
whatever is relevant for passing a just proper decision, see, 311 can be exercised.
No, but the reason has to be stated, the purpose has to be stated on.
The purpose is stated in the last paragraph which you have read out just now.
My lord, no, my lord, that is only, it is written that it is seen some essential facts requiring to be extracted, my lord.
Yes.
But what is the essential?
Not required to be specific. Not required to be specific.
My lord, I have one Supreme Court judgment, my lord.
If during the course of evidence it is found that these are non-essential,
my lord, may kindly see the application, my lord.
That will not have any bearing in the outcome of the case.
My lord.
But then if the court says that certain essential facts, then we have to believe it. We will not go and try to find out why it is essential.
No, my lord, but
that is not the duty cast on this court.
My lord, there is a Supreme Court judgment which says, my lord, the reasons has to be stated.
That is what reason has been stated, the essential facts. It is not that this order doesn't say anything. It doesn't say that prosecution has filed an application, allow the application, reconciliation.
My lord, the order is based on an application, my lord. The application is at page 42, my lord. My lord, may kindly see the application. There is no reason mentioned, my lord.
In the application?
My lord.
But then what happens if that has been recorded here? What is it? What is the allegation in this entire case? What is the case
murder,
about?
murder case, my lord, 302.
302. And who is sought to be recalled?
My lord, the complaint in the PW1. She has filed the FIR now, my lord. The evidence says otherwise.
Our evidence is
it's on
there.
record, yes, my lord.
Have you brought it here?
Yes, yes, my lord.
What is that?
It's page 29, my lord.
Where is the accused now in custody?
My lord, no.
Accused is in custody or is on bail?
He's on bail, my lord.
Yes. That is the evidence of the PW1.
PW1, yeah.
Which has already been recorded.
Already been recorded. My lord, that number 5, my lord, that I do not know who drafted the FIR and could not recall who has told me to put my thumb impression on the body of the FIR is filed and my thumb impression thereon, my lord.
Okay. Yes, Mr. Thaba, what do you want to extract from him? Extract for the witness from her?
Lordship, nowhere in the petition is there even a whisper as to what is the reason as to why the complainant is being called for re-examination. So, Lordship, I cannot argue beyond my petition. But however, Lordship, since the contention is being raised by my learned friend over here, who's stating that this is actually a case of lacuna and not a case of error.
I do not know what happened on a previous day.
Yes.
Just clarify whatever is there right now in the mind of the court. Now, you file an application. You can sit down for a second. So, you file an application under 311.
Yes.
Seeking recalling of this PW1.
Yes.
This petition was allowed.
Yes.
Now, while allowing the petition, the court has recorded some reason, though it is not pleaded in your petition, not raised in your petition. The court has written something, though not in elaboration. It's okay, but then it says that is essential.
It's essential.
Now, what essential remains? What remains? What are the facts which are considered as essential by the trial court?
No.
Even if court says that it is essential, it has to be based upon some materials.
Yes, Lord.
Okay, we may not go into the sufficiency or insufficiency of the materials, but then there has to be some materials. What are those materials?
Lordship, if I may just take, if Lordship may be kind enough to go to section 311 of the CRPC. I just want to read out section 311.
What you want to point out from there? The court's query is about what the trial court found to be essential.
Yes, Lord.
Why this person has been recalled?
Yes.
Why? Your prosecution you have to say, because
yes.
You may not have stated in your petition, but then you must be knowing why you want that person to be examined again. Tell us the reason why.
Lordship, nowhere in the petition has it been stated by the.
You must have some sort of instruction with you, isn't it? You do not
Yes,
have an instruction. Let us forget about the petition for the time being.
First of all, Lordship, a brief reason in the order has already been stated by the learned session court that the re-examination of the complainant is essential in order to reach a for the ends of justice. Now, Lordship, the contention over here right
there
now.
There are two things you see. Yes. If you call a witness who was not at all examined, there is one aspect. But then if you call a witness who has already been examined, there has to be a difference of reasoning.
Yes, Lordship.
You see, if you miss out somebody, there may be a reason that yes, that evidence of that person would be vital for deciding. But then once a person has been examined,
yes,
then you just recall that witness for covering up certain things which you miss out.
Yes.
Now, what are those?
Your Lordship, as Section 311, His Lordship is very well aware.
That's okay. You tell us the reason. Why you are going to law to give your reason?
Nowhere, Lordship, in the petition has it been stated as to the exact reason. But however, Lordship, the main contention is between lacuna and error. As my learned friend had on the last
Why
day.
lacuna and error? Why? What for lacuna and error came?
Because Your Lordships, an error based on the judge.
No. Why we are discussing on lacuna and error?
Yes. We are discussing on it, Lordship, because the error, an error which is committed, an error, that the trial court has the power under Section 311 of the CRPC to recall the witness in order to correct any error. But however, for the filling up of the lacuna, Your Lordship, this cannot be done. So on the last day, when I had stated that before this,
so this is now it appears to be a case
yes,
that you are recalling this witness to cover up some error.
Lacuna. That is what has been stated by my learned.
What you say? Forget about what she says.
Yes.
She will always repeat you. Whatever you say, she will say no.
Lordship, my contention is that since 311, the discretionary power is given to any court. It is plain in the language of Section 311.
You are not replying the query of the court.
Yes.
The query of the court is that whether you want to re-examine that witness for the purpose of correcting an error.
It is for the purpose of correcting error, Lordship. That is my stand.
That is your stand.
Yes.
So you said lacuna error can be corrected, but then lacuna cannot be.
Yes, Lordship. And that is
now, what is the error?
Lordship, there is no as such evidence that I have, but however, Section 311 states that this discretionary power lied before the trial court.
So discretion, by saying that discretion, you mean something unfettered?
No.
That discretion means the court can do whatever it like, whatever the court finds correct, without limiting itself within the four.
Yes, Lordship, provided that it is not lacuna. Provided it is not lacuna and it is.
No. Then how do see if you do not know what is the subject matter? How do we decide whether it is error or lacuna? You have to tell us the reason. Then we can decide upon that whether it is error or lacuna.
And nowhere, Lordship, in the petition has been stated.
Because your petition is causing difficulty to you. Your petition before the trial court is causing difficulty to you.
No, but if Lordship is not satisfied, then Lordship may call for the record of the trial court.
That will not serve any purpose. Will not go and basically and try to re-evaluate the process which the trial court adopted to determine the merits of the decision. No, we are not going to do that.
Yes.
We want to know, only thing is that since you yourself have raised the question of error and lacuna.
Yes.
Now since you are recalling a person who has already been examined, you are definitely doing it with certain purpose.
Yes, Lordship.
So purpose can be either to correct the error.
Yes.
Or can be to cover up the lacuna.
Lacuna.
Now lacuna, as he says, is not allowed.
Yes.
Now you have to tell us for what reason you are calling that witness, so we can determine whether that is to cover up error or for covering up lacuna.
Nowhere in the petition has it been stated.
So if you do not give any reason, then we can say that you are trying to cover up lacuna.
Lordship, that query has been raised by my learned friend over here. So the burden of proof whether this is a case of error or lacuna lies upon my learned friend. It is up to her to prove that this is a petition.
She says that you have not given any reason. So your purpose is obviously to correct the lacuna.
No.
That is what?
She cannot be entirely examined, my lord. There has to be some part has to be examined or some reasons.
Definitely, she cannot be again re-examined just in order to negate whatever has been stated in the cross-examination.
Based on the discretionary power, Lordship, my stand is that
discretion. That is what you see. You want to say the discretion will extend to that. It will go to this something like unlimited discretion, which would basically entail a court to negate what has been taken. Recorded in the cross-examination.
If I may take Lordships to section 103 of the evidence, if Lordship is kind enough to.
Yes.
So Lordship. in section 103 of the Indian Evidence Act, if I may read, Your Lordship.
Please.
The burden of proof as to particular fact. The burden of proof as to any particular fact lies on that person.
Please, sorry to interrupt. Yes. Yes, go ahead.
Lies on that person who wishes the court to believe in its existence.
Yes.
Unless it is provided by law that the proof of fact shall lie on any particular person. Lordship, now the query.
What do we gather from there? 103.
Yes. Now, Lordship, if there's any
you
particular
have referred
fact.
to 103. Now you tell us why you have referred 103.
Because, Lordship, because my learned friend has come before this honorable court in order to seek justice based on particular fact, that is section 311 recall, she's being aggrieved by the recall of the complainant at this stage. So, Lordship, what this section says is that the recalling is that the burden of proof is upon her to prove that it is a case of lacuna and not of error, Lordship, because she is the one who is before this honorable court.
First you say the fact, you see your order or a petition doesn't say anything, then how do you say it is error?
So, Lordship, she is raising the
First
query.
you have to say what the purpose. Then on the question of determining whether error and lacuna will come.
Lordship, I have a
103 has no application here. What 103 has to say? 103 says that whoever alleges they should prove it. That is what?
Very good. Fact. Yes.
Yes. If you go with allegation or if you allege certain fact before the court, then you should prove it. Now comes to that. See, this is why it was challenged, because according to her, that court has come to a finding that yes, there are some essential aspects which should be extracted without any materials on record. Now tell us what is with materials on record. What propelled that court, the trial court, to pass the impugn order on the basis of your petition?
Because it is nowhere mentioned in the petition, Lordship, so I cannot just be.
So you concede that there is no reason stated.
No, Lordship.
No reason
Because
stated, so that means that the order goes.
No,
Because
Lordship.
you are also not been able to tell us the reason.
No, that is not the thing, Lordship. There is a clear ruling by the
You see,
Supreme
it is
Court.
not for the trial court to take into consideration 161 statement and compare it with the evidence and recall by a person. Is it the duty of the trial court to do it if prosecution doesn't want it? The first of all, the question of comparing 161 probably or bringing, you see, is very restricted in view of that provision of 162. 162, you know, that 161 can only be used for the purpose of bringing contradiction to the witness. That is, the use is confined to that stage of evidence. If it is used then on the judgment and all, it can be reflected, but to that extent of, you see, like bringing contradiction. But then not for any other purpose. Now here it appears that court has determined the purpose of recalling that witness on the basis of statement of 161. Now the court must have extracted something from 161. Now what is that? Otherwise this person stood examined by the court.
Yes, sir.
Now just because there exists a difference between what is stated before the court and what is stated before the police cannot be a reason for recalling. Can it be?
But it has been stated in the order, Lordship, that it is very essential to recall the witness.
Tell us why it is very essential. You are now on the point.
Yes, Lord.
Now the court has given a finding essential. Now what is the materials basing on which it was handled? If you cannot show any material, then we will say this finding is perverse and will be good ground for interfering in the revision of the jurisdiction. But then if you show something, then we may not determine.
Lordship, may this matter come up next week, Lordship. I'll pray for time for seeking instruction in this matter because I have to seek instructions, Lordship, in this matter.
Your petition is nothing. There is no disclosure, anything, why you want it. The court has given a reason that perusal of 161, the court found that some essential aspects has to be extracted from the witness. Now, if it is just merely for the reason that the witness has stated something else than what she had earlier stated in 161 can be ground for recalling. And see, prosecution cannot use that 161 statement to confront the witness. It is only the defense who can use it.
The reason, Lordship, that the trial court is in no way in error in passing this order, Lordship. No way in error. As Lordship has stated that there is no reasons given. The trial court is no way in error because the Supreme Court has already ruled that the reasons given for recall must be brief. Must be very brief, Lordship. So, based on that ruling,
it should not say must be very brief. It may not be elaborate. I don't think that Supreme Court will any objection if trial court gives an elaborate reason. Okay. The only thing is that the law requires that there should be a mention of reason. Now, do you want to say that this court will not have even the power to see what is the reason without going into the merits of the reason?
So, Lordship may call for the...
Tell us what is the reason.
Lordship may call for the records.
No, there is no... Record will not help us. So, record will definitely not help us.
I will satisfy your Lordship.
Definitely, you are a young man, you see, we would definitely like to hear from you more.
Yes, Lordship.
There is no problem with that. But then the thing is that, see, you have to justify this order, isn't it?
Yes, Lordship.
Now, if court says, just on the basis of your petition, apparently there is no reason in your petition, court says, no, there exists essential, this thing, there exists some reason. Now, we must see that there exists something basing on which that reason is extracted.
Yes, Lordship.
Now, what is that something?
I'm praying for this 1 week time, Lordship. Lordship is kind enough. Satisfy your Lordship.
See your petition, page 42, isn't it?
Page 42.
See, if you go by the reasons also, then your petition should be rejected. We can extract a reason. You see what it says, the first paragraph.
Yeah, read, Malad. The prosecution would like to file the instant application for recalling and re-examine the below mentioned prosecuting witness who is the complainant in the instant case as her evidence appears to be essential for the prosecution.
Yes, the evidence has been recorded. Finish. Evidence appears to be essential, evidence has been recorded. It is not a case that evidence has not been recorded. This you say when you call a witness who has not been examined.
Based on the materials, Lordship, that I have right now, all I can say is the burden of proof is for my learned friend. But Lordship,
what burden of proof?
Burden of
Well, the application is filed by them, my lord.
She has shown out, she has pointed out, she has made her submission. She says that the very finding recorded by the trial court is not based on any materials on record. Now, this court also apparently on perusal of the documents appended finds no material. Now, this question is to you. Show us what is the material.
I'll satisfy your Lordship if Lordship will just kind of.
We'll give him some time.
Yes.
Please see that thing. See, we do not get diverted and all. Just remain to that issue. This court will definitely not ask you to basically, you see, like point out to the merits of your claim and all. See, we'll just say that only one thing is that what this court would like to tell you that please bear in mind that there will be definitely a difference. There exists a difference when you call a person who has not been examined and you recall a person who has already been examined. Now, when you recall a person, then as you say, then you have to show us that this recalling is for the purpose of correcting some error and not looking. Okay, but then here in your petition, you never say that there exists or there appears to be error.
Yes.
That is what.
Okay.
Well, just say, Mr. Thaba Lanet GA. Hard, just say both the counsel. Then you say, Mr. Thaba Lanet GA, please for some time. Please for some time to prepare the matter. The petitioner has no objection. We are allowed least after a week. 1 week will do?
Yes, Lord. 2 weeks, Lordship. 2 weeks.
No problem. 2 weeks, just say. It's good that you see, the young lawyers should prepare and come. You see, you should not come and just mention that senior is not there, not there. Do the cases by yourself.
Yes, Lord.
We all grew up by doing that.
Highly obliged.